To me, the right to remove and replace the trustee is one of the most critical things that should be in any trust. Over the course of my career, I've had a number of situations where someone has said to me, we had the bank administering the trust, and it was a terrible experience. They didn't do this, they didn't do that. The this and that may be expressed as they didn't invest very well, they didn't communicate very well, they didn't seem to follow the terms, they weren't responsive. Whatever the frustration was, though, at the bottom of it, the problem probably was that within the terms of the trust, there was no mechanism to remove a trust company that didn't perform very well, and that actually had to be removed by going to court and proving negligence. So mere mediocrity or occasional stupidity or rudeness in treatment by someone on the staff wouldn't be sufficient. And that would lead to a tremendous frustration. If you imagine, if you have the plumber, the attorney, the accountant, whoever it is, who provides a service, and they don't do what you'd like them to do over a period of time, you figure, well, I'll get rid of them, I'll hire a new one, and that's the end of that. And a beneficiary who doesn't have a removal provision in a trust doesn't have that wherewithal. They have the right to go to court. There is still a fiduciary duty that the trustee has to them. It's not that the trustee is a dictator or operates in a lawless society of its own, but the trustee has to be proven negligent if there's no standard by which to remove them otherwise. So it's something that we've often spent a lot of time on, and I also think that over time, the time that I've been in practice over the last 24 years, I've seen a greater amount of time and concentration spent by other attorneys on this very point. And the broader point is trustee continuation, trust succession, what the trust management will be over the longer period of time, and who has the right to determine what the outcome of that is. Now, when you have trustee removal and replacement, you have to consider that if you're keeping the trust out of the grantor's estate and the spouse who is named as a beneficiary is going to have the right to remove and replace the trustee, they should have that right so that they can't name somebody related to the grantor or to themselves. They can't name a related or subordinate party where they effectively become a quasi-trustee themselves. So you'd want to keep an eye on how the estate tax law works. Typically, the grantor with an irrevocable trust, such as a life insurance trust, is going to have the right to remove and replace, but can only name somebody who's not related or subordinate. And that would follow generally the terms that are contained in Revenue Ruling 9558 that address that point in more detail. Beyond that, you'd want to keep an eye on who the other players are. For example, one of the terms that we've seen in the last several years is a trust protector. A third party who could be a co-trustee or could just be a third party who has the right to remove and replace the trustee. Very often as we set up a trust, if we have the co-trustee arrangement we talked about before, we may have an individual trustee and a corporate trustee and give the individual trustee the right to remove and replace the corporate trustee. Chances are the corporate trustee is not going to remove and replace themselves. They're the ones who are typically being judged in some manner, and the individual trustee would be the ones who step in and remove and replace them. You may also want to have it so that the individual trustee can designate a successor, and that successor, while acting as an individual trustee, can in turn designate a successor. So then you have a chain of succession that runs on for the likely duration of the trust. One of the things to keep in mind there is if you have, for example, a special needs trust, which may run for someone's lifetime and may well succeed the lifetime of the various individuals involved, you'd want to have a corporate trustee all the way through there to have that continuity. You may have a trust set up for children who are now at a young age and after the parents die won't get a distribution until, say, age 35 or age 40, a final distribution. But along the way may get interim distributions, and perhaps at age 25, for example, should have the right to remove and replace a trustee, provided that they're replacing the trustee with a corporate trustee so that they don't name their friend, their buddy, some other individual who will do their bidding to act as a trustee, but nonetheless gives them some flexibility so that they're not forever tied to the bank or trust company, that over time may have different iterations. There may be mergers and acquisitions, and what was a wonderful company becomes a terrible company, and then the beneficiary feels stuck with that. So if they have the right to have that removal and replacement power, it will definitely make life happier for them. It's also a good thing, I think, that keeps the corporate trustees somewhat on their toes, knowing that it's there. They have to pay attention to the fact that there are people there that they have to satisfy, and if they don't, just like the rest of life, someone will name someone else that will do a better job than what they're judged to be doing. So I think it's a really critical provision to have. It's something that you want to make sure that in drafting that or preparing that, make sure that you're in tune with the grantor and what their ideas are as to succession, and also that they understand the authority that's given to the individual trustee or the protector, or perhaps the individual beneficiary who's the adult, becomes the adult child, as to the right to designate and what the meaning of it is.